Heiss, you can come forward to the podium if you'd like. This is file 23-51140-DM, Ashley Ann Heiss versus Nicholas Charles Heiss. We are here today for a hearing on an order to show cause regarding payment of child support. We are proceeding today in person. Sir, you are Nicholas Charles Heiss?
Yeah.
Mr. Heiss, you're before the court today on an order to show cause. According to the information I have from the front of the court, you have a monthly child support charge of $899, and there's currently an arrearage in the payment of support in the amount of $15,019.17. Do you understand that?
Yeah. I'm
okay. Before you say anything, I have to ask you some questions to make sure you understand what your rights are. So I'm going to do that, and then if you choose to say something after that,
okay.
you're welcome to. So, do you understand that it's a crime to fail to pay child support to the best of your ability up to the amount ordered?
Yeah.
Do you understand that you were to plead guilty or be found guilty of that offense, that the court could sentence you to jail for up to 30 days?
Yes.
You are entitled to have a trial, and you can't be convicted unless the evidence at your trial proves that you're guilty beyond a reasonable doubt. Do you understand that?
Yes.
You're also entitled to be represented by an attorney here today and at any other proceedings that we have regarding this matter. If you can't afford your own attorney, you can tell me that, and I would appoint one for you from the public defender's office. Do you understand that?
Yeah.
Do you want to be represented by an attorney?
It kind of depends on how today. So may I speak for just a second? I think I'm okay. I understand what you're saying. I don't know, because the only thing I was unclear on when I was answering that question is I'm unclear on the amount. I'm aware that I do owe some child support. But like, I know that I got confused the last time that I talked to somebody from the courts, because I called in and I was like, hey, I'm making payments directly to her now. So like, they're not being tracked. How do I go about that? And then between me and my ex, we had some miscommunication on how we reported to the court that I had paid her money. And then and then I heard in my head, get back on track with payments and we should be good, and you won't have to come to court, right? And so that's what I heard. It was a miscommunication between me and the court, whoever I talked to. So I paid her more money, but just to her. And then she emailed where she thought she was supposed to be letting the court know. She was like, okay, I sent an email over here and let him know that he paid me directly and everything was supposed to be good. Well, then I got a warrant for my arrest, and I was like, Ashley, are you letting them know? And then she called the court and said, he's paid me X amount of dollars. And they said, okay, we'll revoke because that threw me for a whole loop. I knew that I was behind. So it's like, yes, if I needed an attorney to keep going, I knew that I was behind. I started a business this year, so my payments have been sporadic. I do contracting. So when jobs finish, I usually give her more money. But even since the last time I gave her money and we talked to the courts, like we were going to set up like the card through the courts. And yesterday I just gave her cash again, because that was just what was convenient for the whole thing. So it's like,
okay, let me stop. Yeah. Let me stop. Okay. So when you just give her cash, no one at the front of the court knows about it.
She has to report it.
She has to report it.
Right.
And if she doesn't report it, or she reports it to the wrong person, you end up having to come to court.
Right, which we had that issue.
The alternative is to do it what I would call the correct way, and make your payments through the friend of the court, which, although mildly inconvenient for you as opposed to giving her cash, avoids the greater inconvenience of you getting hit with a show cause charge and having to come here, or perhaps having.
I fully don't disagree, and I thought we actually had like okay, she's going to get on this like card thing, and I can deposit money electronically, because there's been a couple issues where it's like, if you put money in electronically in my bank account's negative, and I won't go. So it's like we work together pretty well. In fact, I'm actually framing and drywalling a basement or a room and her and her boyfriend's basement for their son this week. So it's like, we're just bad at communicating with the courts. So it's like, I don't feel like I need a lawyer, because I feel like even if she was standing right here, she'd be like, yes, we're just really bad at communicating with the courts. And we need to do better at that. I need to do better for sure. I need to take the reins on that, because
it doesn't matter if you take the reins or not, because when you make a payment to her, she has to sign a receipt and get it to the front of the court.
Yeah.
And if she doesn't do that, you're gonna keep coming here.
Yeah.
Every time it happens.
Yeah.
Because my job is to make sure that it's paid.
Yes,
right?
Yeah.
Or hold people accountable when they don't.
Yes, I
And
understand.
so if the friend of the court reports to me, hey, we don't have any records of any payments.
Yeah.
We've got to come through this process.
I totally understand.
What I'm going to tell you to do is get your payments set up through the friend of the court.
Okay.
And make them that way.
Yeah.
And don't rely on her.
Yeah.
To do anything else.
I found that was a bad idea. They were on their way back from a hockey game, and they stopped at a job site that I was at, and I gave them money. It was just like, it being Christmas. And truly, I'm a new contractor, and I'm really not very good at first of all, making a bunch of money on every job. Every job I make less than half of what I thought I was going to. And then also finish dates are like, I don't know if you ever had your housework done, but if you can imagine somebody in their first 2 years of owning a carpentry business, it's like, and Ashley's been really nice. I was supposed to, I told her I'd get her money on the 1st, and I finally gave her money yesterday, and it was just, but I couldn't get paid from my customer. So we've been very communicative with everybody except for the court, and I will take it upon myself and get that corrected, because obviously it's not her that they'll call in here if she doesn't make the phone calls, but I do apologize for that.
And I understand where you're coming from. I also know that because I've worked with contractors in your situation before, and I understand that the income fluctuates. But I also understand that it's hard to get out and do your jobs and get them completed if you have to keep coming to court.
Oh, 100%. Yeah, I was supposed to be in and row this morning.
This is the thing you want to avoid, I would think, above all else. So
100%, Your Honor.
So what I'm going to do is adjourn your hearing to January 12th at 8 a.m. And obviously, it's in your interest to get child's mother to report to the front of the court what you have paid her recently. But also, what I'm going to be looking for is that you have your payments set up through the front of the court, so that we can keep track of this and not have to constantly be calling you into court and
I agree,
chasing her down to get receipts. So all right, so January 12th at 8 a.m. will be your next hearing. You can attend that by Zoom if you prefer to attend by Zoom. They're just going to hand you our information for doing that.
Thank you so much. Okay.
Okay, so you're all set for today.
Okay, thank you so much. You have a great rest of the day, you guys.
Thank you.
That's got to get somebody every once in a while with this is a poll. Somebody every once in a while go over it, just about. You know, to walk through it. Yeah, I bet.
Okay, we can call Brad Veers. This is file 22-50167-DP, Ashley Helen Knight versus Bradley Dean Veers Jr. We are here today for a hearing on an order to show cause. We are proceeding today by video conference. The courtroom is also open to the public. The record should reflect that this case was set for a show cause hearing this morning at 8 a.m. Mr. Veers was ordered to appear here to respond to the show cause. It is now 8:16 a.m. and Mr. Veers has not appeared either by coming to the courthouse in person or by logging into the Zoom session. I am going to issue a bench warrant for his arrest, and I will set bond on that bench warrant in the amount of $6,355.45. Brandon Martin. Was he still in jail? Oh, is he? Yes, please. Ms. Underwood, are you going to need to speak to Mr. Martin when he gets here?
Could I speak with him, Your Honor?
Yeah, when they get him logged in, I'll put you in a breakout session with him.
Thank you.
I guess he's still at the jail.
Good morning, fellow judge speakers. Could we have Brandon Martin in room for the judge, please? Brandon Martin. Thank you. Bye.
Is Mr. Martin still in jail, Your Honor?
Yes,
Okay.
we just called, so they should be logging in with him in a minute.
Okay. Well, I had in my notes he was going to be out, so I tried to. Okay.
Okay, Mr. Martin, I'm going to put you in a breakout session with Ms. Underwood if you give me just a moment.
All right.
You packet versus. Okay, Mr. Raines, is Mr. Loop with you?
Good morning, Your Honor. Yes, he is.
Okay, just making sure. All right, then. This is file 10-39039-DS. Ashley Renee Hackett versus Seth Allen Loop. We are here today for a hearing on an order to show cause regarding alleged parenting time violations. We are proceeding today by video conference. First, Miss, you are Ashley Renee Hackett.
Yes, Your Honor.
And Mr. Raines, would you like to place your appearance on the record?
Yes, good morning, Your Honor. Matt Raines appearing on behalf of and with the defendant, Seth Loop. He is participating in the hearing from my office.
All right, and sir, you are Seth Allen Loop.
Yes, sir.
Mr. Loop, you're before the court today on an order to show cause alleging some parenting time violations. If you were to plead guilty or be found guilty of the violations, the court could take a number of steps according to statute. Those would include requiring additional terms or conditions with your parenting time order, ordering makeup parenting time, assessing a fine, placing you on a form of probation with the front of the court office, and also committing you to the county jail in order to get you to comply with the parenting time order. Do you understand that?
I do, Your Honor.
Do you understand that you have a right to a trial and you can't be convicted unless the evidence at your trial proves you're guilty beyond a reasonable doubt?
I do.
And you obviously have Mr. Raines representing you with respect to this issue. Mr. Raines, do you know how Mr. Loop would like to proceed today?
Yes, Your Honor. Mr. Loop would plead not guilty. We'd request that we schedule an evidentiary hearing on this matter. Judge, we did file a motion to modify parenting time. That was just filed at the end of last week, and I believe we have a hearing date scheduled of January 5 right now. I'm only mentioning that for the sake of judicial efficiency, if perhaps those can be consolidated, although I presume that that January 5 date would just be a motion hearing date. But I wanted to let the court know that that's pending, and if there's some scheduling that can incorporate a hearing on the parenting time motion, that might be appropriate.
Okay, so the complication is that we need Mr. Brueggemann from the prosecutor's office because he handles the contempt hearings. So what I'm going to do is set that for January 6th, which will be the day after the hearing on the motion to modify parenting time. So that's the day that Mr. Brueggemann will be here. So January 6th at 8 a.m.
Very good, Your Honor. Will the court be issuing a notice?
Yes. Okay, so I think we're all set there. January 6th at 8 a.m. will be the next date on this.
Very good. Thank you, Your Honor.
Your Honor,
Thank you.
if I may, just given the amount of time, the length of time that this has been going on, and I didn't receive notice of that motion until 4:21 on Friday afternoon, I would respectfully ask that the court order Seth to abide by the existing order in the interim, given the upcoming holiday and the extensive amount of time already missed.
All right, Mr. Raines is well aware, and I'm sure he has briefed his client on the court's position that a parenting time order is the order of the court and should be followed at all times until there is a change in the order. So they're issuing an order to say follow the order, in my opinion, is redundant. So I don't think that's necessary. The parenting time order that's currently in place is the parenting time order, and that is what the party should be following.
Thank you.
Understood. Thank you, Judge.
Thank you. Then you can go ahead and log out. Okay, this is file 10-35078 DP. We are here today for a hearing on an order to show cause. We are proceeding today by video conference. This is Abigail Susan Mole versus Brandon Matthew Martin. Ms. Underwood, would you like to place your appearance on the record?
Rhonda do it for Mr. Martin this morning, Your Honor. Thank you.
Okay, and where do we stand with Mr. Martin's case?
Mr. Martin, Your Honor, will be in jail until December 22nd. Obviously, that does not make payments possible at this time. However, we would ask the court to continue the not guilty plea, allow Mr. Martin to get out of jail on the 22nd, and set this matter for perhaps the middle of January, Your Honor, by which time Mr. Martin hopes to have employment and be able to start making payments, Your Honor.
Okay, what I'll do is set this then for January 12th at 8 a.m.
Thank you, Your Honor.
Thank you. Mr. Martin, you're all set. You can let the officer with you know that you're done with court for today.
All right, thank you.
Thank you. Okay. This is file 96-18024-DP, Rosalinda Quist versus Anthony Benjamin Ford. We are here today for a hearing on an order to show cause. We are proceeding today by video conference. The courtroom is also open to the public. The record should reflect this matter was set for hearing this morning at 8 a.m. It is now 8:29 a.m. Mr. Ford has not logged into the Zoom session and he is not present here in the courtroom. I am going to issue a bench warrant for his arrest and set bond on the bench warrant in the amount of $7,449.68. And I think that that takes care of all of my friend of the court cases for this morning.
Your Honor, can I just ask about, hang on.
Thank you, Your
had a
Honor.
couple. That was Mr. Ford, Your Honor, that you just did?
Correct.
And was there a oh, Was there a John Dotson, Your Honor?
Mr. Dodson was adjourned to January 26th.
Thank you. Have a good day.
Thank you, you too. Okay, thank you, Rhonda.